Court calls case People versus Tariq Day.
Nimish Ganatra, Senior Assistant Prosecuting Attorney for the People.
Hello, Tariq Samar, Tariq Day here.
Already, Judge Torsho Feaster, Assistant Public Defender, on behalf of Mr. Day.
He's there. Can you turn on your camera, sir?
I don't have any contract with a public defender's office.
You what?
I don't have any contract with the public defender's office to represent me.
You don't have a contract with them?
Correct.
Yes, Judge. I reached out to Mr. Day to try to help pre-try this case.
It's going to be a Bellinger's thing?
I think so, Judge.
Okay, go for it.
My understanding is that he had enough counsel that he's going to have, I believe, on his file. And I wish him good luck if that's the case, but I don't see another attorney here, so I don't know what's going on, Your Honor.
No.
Mr. Day?
I'm defending myself. I told him that I would notify the court that I relieved him of any implied obligations to this case.
It makes sense that you reacted that way, because you've probably spent the last few nights watching a bunch of online videos and now feel fully trained in the law. And somehow, that seems to make you more confident than the actual attorney who's standing right there to help you. People often think a few clips can replace real experience, but the courtroom quickly proves otherwise. In moments like this, it becomes clear why professional guidance matters and why relying on real expertise can save a lot of trouble.
So you're going to represent yourself?
I'm defending myself, correct.
Okay, then you need to be here. Now.
Well, as I told the court, I requested a Zoom hearing because I have COVID. So there's no way I can.
In a vehicle with a hat on, no mask. Oh.
I am inside my vehicle right now.
What'd you say?
I said yes, because I'm inside my vehicle right now. I work outside. I'm away from the general public.
Did you go to the hospital regarding the COVID diagnosis?
Excuse me?
Have you been to the doctor regarding the COVID diagnosis?
It's against my religion.
Okay, so here's what you're gonna do. Then I'm gonna say, okay, you got COVID. I want you here. When's our last block? 3 o'clock today. Wear a mask if you're gonna represent yourself.
I can't make that. Is there a later date?
Oh, yeah, you can. 3 o'clock.
3:30, I can make that.
You can either show up at 3 o'clock, or you can spend your weekend dealing with the consequences. This judge isn't someone who lets things slide. This is Judge Simpson, and he takes his orders very seriously. If you ignore what he tells you, he won't hesitate to take action. People who underestimate him usually learn very quickly that the courtroom has strict rules, and following them is the simplest way to avoid unnecessary problems. In situations like this, cooperating is always the smarter choice.
I'll be here at 3 o'clock.
Well, I'll be there at 3:30, and if there's any issue, then
okay, and at 3 o'clock, I may issue a bench warrant. Be here at 3 o'clock. I'll pass this matter. Thank you.
There's no bench warrant to be issued because this court didn't have.
Okay, I'll determine that at 3 o'clock.
The court
See
didn't
you at
have.
3 o'clock. Thank you.
This court does not have jurisdiction.
You're welcome, Mr. Feaster. Cut his line. Why don't we do this? Give me about 3 minutes. I'm going to take a recess, then I'm going to come back because everything's going downhill, and it's those two guys' fault.
So now we're just inventing new meanings for legal terms as we go along. That's not how the law works, and changing definitions doesn't magically make something valid. Let this be a reminder for anyone watching. Relying on random ideas without real understanding can lead to some very confusing situations. When people keep following misleading information without proper guidance, things can get out of hand fast. It's always better to learn from credible sources and check with someone who actually knows what they're talking about.
What's your name?
Tariq Samar Tariq Day, the executive of the Tariq Samar Tariq Day Living Trust. Glad owner Martari Wilson Estate.
Sir, you indicated that you wish to represent yourself on this matter.
Yes.
All right, you understand at your arraignment, you were given the charges that were have been filed against you?
I was given a charge. So if there were any additional, I was not given those charges. The only charge I got was a fleeing and eluding.
Fleeing and eluding, third degree.
Third degree, correct. And if anything else was tallied onto that, then I was not told.
I have one charge.
Okay.
That is a felony punishable by up to 5 years incarceration and $1,000 fine plus court costs. The Secretary of State would be required upon your conviction to suspend your license for a period of 1 year. You understand that, sir?
I do, but I have some questions.
As soon as I get through this, you have indicated that you wish to represent yourself. I have to advise you that there are some dangers in you representing yourself. You understand that, sir?
I do comprehend.
And you understand that if you proceed to represent yourself, that the court is not going to assist you to understand the procedures or anything regarding the court proceeding, that you will be responsible for that, and I will be holding you to the same standard that I would be holding the attorneys in the room in terms of even ruling on evidence or anything along those lines in regard to the procedure and the process. You understand that, sir?
Correct, I comprehend.
All right. You also, so I will ask you again, do you still continue to wish to represent yourself in this matter?
Yes, I will be defending myself.
You understand also, sir, that should you change your mind and could not afford to hire an attorney and wish to be represented by an attorney, the court would consider making sure that you are afforded counsel. You understand that?
I comprehend.
How do you wish to proceed on this matter, sir?
First, I want to like an oral motion for dismissal based on the fact of the lack of probable cause and also the lack of personal and subject matter jurisdiction based on the fact that this is a trust matter from the name to the private conveyance that was stolen by the third party, Wall Street Towing, and impounded on the colorful law actions of Officer Trowbridge of the Washtenaw County Sheriff's Department.
I still find it interesting how some sovereign citizens genuinely believe they can shut down an entire court system just by declaring a judge or court officer a fiduciary or beneficiary of a trust they invented. The problem is, the trust they're talking about isn't real. And even if it were, that's not how the legal system operates. It has never worked that way in the past. It doesn't work that way now. And it's not going to work that way in the future. Courts run on actual laws, not personal theories. And trying to replace established procedures with imaginary rules only leads to more confusion and trouble for the person making the claim.
Also, I have not been able to, as of Constitution Amendment 6, being able to face my accuser. With the state of Michigan being a fictitious entity and there's no injured party, there's no crime that has been committed. And again, to the probable cause of the initial stop and the arrest cannot be proven. There was no probable cause for the arrest or stop. There was no warrant on hand for the arresting officer to conduct an arrest. And even more so, again, as I stated, this is trust property, so this court doesn't have jurisdiction to adjudicate over the foreign trust.
Okay. Finished?
Oh, no, actually, I was also moving to place you and the clerk as fiduciaries over the trust, and I'll be able to supply you all with the adequate assurance certificate of security to settle and offset charges.
I have a genuine question. Have your documents, or the same approach used by others who follow this method, ever actually helped you in a case? No. All right. Then that should tell you something important. If a strategy has never worked, there's really no reason to keep relying on it. At some point, it becomes clear that using proper legal guidance is far more effective than repeating ideas that have never succeeded. In the end, choosing the path that actually leads to results is always the smarter move.
Well, you will be doing nothing to me and nothing to my clerk. So whatever that motion was, that's denied. As to your other motion regarding all of that, quite frankly, it doesn't make any sense. We haven't even had the probable cause hearing. There will be a determination at the next stage as to whether or not there's probable cause regarding the charges.
I was told this was a probable cause hearing,
This is a probable cause hearing.
so I don't understand what you're saying.
I know you don't understand.
They're not having a probable cause.
Pardon?
You said that no probable cause was had, but then you said that this is a probable cause hearing.
You have not had your preliminary examination, at which there will be a determination as to whether or not there's probable cause to believe that the crime has been committed and you committed it. That is the next stage. That has not happened. So to the extent that your motion is even valid, which I do not believe that it is, and certainly you may raise it at a later date, but to the extent that it's valid, at least at this point, your motion is premature, and therefore your motion is denied. Anything else?
Well, lastly, I want to also put on the record, I wasn't able to provide all my exhibits based on, as I told you, I was
You weren't able to do what?
provide my exhibits
To whom?
to the court to help for my defense, the evidences.
You haven't had a hearing yet.
I comprehend it. I'm just saying that I usually have my documents precede me before any hearings take place, and I wasn't able to because I was under the weather. That was my point.
If I were you, I'd take that warning seriously. Anyone who has watched Judge Simpson knows this is actually his calm side. He usually sends uncooperative adults to spend some quiet time in the Washington County Jail so they can rethink their choices. And the officer standing between you and the door is there to make sure things stay orderly. When people push the judge's patience, the outcome is rarely in their favor. Following the rules and respecting the process is always the wiser path, especially in a courtroom where every action has real consequences.
So they will be here, if not by the end of the day in the drop-off box, and you'll have more tomorrow. But you all will be served with the proper documents, and the taxes as well will be filed on the case.
Okay. Anything else?
No, not at this time.
All right. So how would you like to proceed next on this?
I'm entering a plea of demurrer.
Okay, you've already done that.
I've already entered a plea of demurrer. I'm not sure when that took place other than right now.
That took place on the arraignment on the complaint, sir.
I never pleaded demurrer. There was
You stood mute, you stood demure. You don't even know what that means. You're just using words and have no concept
No.
as to what they mean.
demurrer and mute are two separate things, but that's neither here nor there.
No, they're not. You have no legal degree. They are not,
No need to.
they are not,
I'm not here.
they are virtually the same thing. So where do you wish to proceed now?
As I stated, my
Do
motion,
you wish this set for preliminary examination? Your motions have been
I
denied.
wish for the prosecution to provide the evidence that any of this needs
You
to.
don't have discovery on this case. Is that what you're asking?
I'm not asking for discovery whatsoever.
So what are you asking for?
I stated that the prosecution needs to prove that a crime was committed, and they also need to show and prove that there is an injured party for the crime to have even been committed.
As I've indicated, you will have that hearing. Do you wish to have discovery?
Discovery should be provided regardless. There's no wish about
Do
it.
you wish to have
Discovery should be
discovery?
provided.
Don't play word games with me.
I'm not playing with
Mr. Allen,
discovery.
not play word games with me. You're playing with the wrong judge. You can smile and smirk all you want.
I'm not trying.
I'm giving you your warning.
Let's break this argument down. The court does have personal jurisdiction over you because you have appeared before it. If the court didn't have jurisdiction, there would be no reason for you to show up, and any threats or pressure would be meaningless. This is similar to how some sovereign citizens hold meetings in parking lots and try to bring charges against actual elected officials. Yes, this really happens, but it's like a student council in high school, except with people who never even attended school properly. The elected officials never appear because the group has no authority over them. Without personal jurisdiction, the court can't act, which is why showing up and following the proper process matters so much.
Send those to him.
Yes, I do. I can confirm it with him too.
All right. What do you have as the address? Do you have an address on, is it share?
I do, Your Honor.
Okay.
11410.
Okay, gotcha. All right, you'll make sure that that is sent to him.
I will.
You also have an email address so that all things can be emailed to him also.
I do, Your Honor.
All right. Very good. Sir, did you wish to then have another PCC, or did you wish to proceed immediately to preliminary examination?
I would like to first have a jurisdiction hearing,
What kind of jurisdiction here?
personal and subject matter.
Okay. Go ahead and raise it because I can deal with it right now. What's the personal jurisdiction?
This court, as well as the state, lacks personal jurisdiction. I'm simply here under threat and duress of coercion of you, saying that you would hope put out a bench warrant for my arrest.
Once again, that argument doesn't make any sense. Article 1, Section 10, Clause 2 deals with excessive taxes on imports and exports, not everyday traffic stops. Your boat was impounded because you chose to flee from the police during a traffic stop, which has nothing to do with that part of the Constitution. Trying to apply that clause here is completely irrelevant. It's important to understand which laws actually apply, or else these arguments will keep falling apart. Following the proper rules is always what matters in situations like this.
The subject matter in regards to the name as well as the vessel that was used is again under, it was conveyed and is held and protected within the trust. And according to Article 1, Section 10, Clause 2 of the United States Constitution, there could be no legislative laws that could intercede or to interrupt the functioning of a contract, which the trust is and is properly properly functioning at this time. So,
of course you'll show up, because deep down you know your argument isn't very strong. This isn't about a trust court or some made-up corporate court. This is your actual court date. If you don't appear, it will be you facing serious consequences, because the court does have both personal and subject matter jurisdiction over you and your case. Alright, that wraps up this video. It looks like we'll be seeing this person back in court on April 25th, and I'm genuinely curious to see what happens next. If people are going to make up words, then it only makes sense to stick to facts and real law. If you enjoyed this video, hit the like button. If not, feel free to hit dislike, but don't forget to leave a comment below. And make sure to subscribe with notifications turned on so you never miss any of my content.